This is a very different world than the one that existed just a generation ago. In the past 20 years, our lives have been transformed by amazing advances in technology, and none has been more life-changing than our ability to communicate with each other all the time, everywhere we go. Most tweens and teens now have powerful communication devices in their hands, their pockets, or their backpacks, so they can be in touch at all times with parents, each other, and the social media platforms that have begun to supplant real-life circles of friends. Even many younger children have their own devices. School classrooms are now full-blown digital experiences, with computers and software beginning to replace teachers as the preferred method of education. For the moment, most school kids still have pencils and notebooks, but increasingly, their work is completed on iPads and laptops.
How is this deep immersion into technology affecting our children? And how is it impacting their emotional health, their interpersonal relations, and overall well-being? That growing concern among parents, educators, sociologists, scientific researchers, medical doctors, and legal experts was the spark for a groundbreaking new document which is now circulating around the world, the International Declaration on the Human Rights of Children in the Digital Age. The declaration is built on the foundation of the 1959 United Nations Declaration on the Rights of the Child. The new declaration expands on that notion, setting out 3 specific rights which all children around the world must have in this new digital age. The right to be free from addictive platforms and apps, the right to be free from hazardous electronic product radiation, and the right to be free from commercial exploitation.
The protection of children is already a part of international customary law. The basis for international law are the decisions of the International Court, international treaties and conventions, and what is called customary law, which is an independent basis for the creation of legal norms. You can sue in the United States under U.S. law, implementing and incorporating international custom, as you can in other countries. It's self-executing. And so it seemed to me there was a legal principle here that was important.
That's Julian Gresser, lawyer, philosopher, inventor, twice Mitsubishi visiting professor at the Harvard Law School, and a visiting professor at MIT's program on science, technology, and society. He's the primary author of the International Declaration on the Human Rights of Children in the Digital Age. Early in his career, Julian had discovered environmental law and was immediately drawn to its ability to positively impact people's lives. In particular, Julian was drawn to the idea of making polluters pay for the damage they had caused. As a young man, he worked as an environmental lawyer in Japan, helping to formulate the way in which polluters in Japan had to pay for their emissions, and then was invited to teach at Harvard Law School.
I then got picked up after my work in Japan by Professor Jerome Cohn at Harvard Law School, and I taught a course with 2 Japanese law professors of environmental law, and we looked really hard at the issue of toxic torts, particularly these pollution-related injuries of Minamata disease, mercury, cadmium, all the problems of air pollution, and the innovative approach the Japanese took to creating a fund based on an emission charge that the polluters had to pay that was calculated by the damages that they caused. And they felt it was unfair to make the public pay, and the burden of proof was very extreme. Now, there were some major cases in Japan that shifted the burden of proof onto the companies. And then one of the students had the bright idea, which was developed in the course, to introduce the same idea in the United States, and that became the Superfund legislation. So this whole issue of releasing a dangerous substance on a helpless public is something that I had this track record of having basically developed the evidentiary legal basis under Japanese law for U.S. law in that area. So it was natural for me to see the connection and how many of the critical issues that are faced today were addressed in these earlier cases 50 years ago in Japan. The critical issues of causation continue, whether it be Love Canal, lead poisoning in water, Flint, Michigan, Erin Brockovich. All these issues continue to come up. And so the polluter pays principle was articulated by the OECD in 1972.
That's the Organization for Economic Cooperation and Development, an intergovernmental organization with 38 member countries founded in 1961.
With a very strong economic theoretical basis that these are so-called externalities that the companies, in order to extract profits, are being subsidized by not having to pay these externalized costs. They're off balance sheet. And so the polluter pays principle was designed to say it is inefficient for these costs to be not borne by the companies causing them.
Inefficient and unfair. Consumers who are negatively impacted by some sort of environmental pollution have a steep uphill climb ahead of them in court as they seek to prove that it was the actions of the polluter which caused their problem. With so many toxins in our lives, positively teasing out the one that is responsible for a given outcome is extremely difficult, even when the pollution caused by the company is known to cause human harm. And that's what allows polluting companies to keep polluting. And it's where public interest law comes into play.
It's now become really an international movement, and we really understand where some of these pivotal leverage points are from a legal point of view, which is part of the art of public interest law, which is to take large issues but find in a legal sense where can we do massive amounts of good with sort of artful, very well-focused legal intervention. And this area is, I think, ripe for it. And within it, the protection of children is an area that really deserves careful attention, which was what motivated me to conceive of this international declaration for the protection of children in a digital age. It turns out that children, as we know, are enormously vulnerable. So that was the first motivation. And then it seemed to me, given the data that actually you guys have developed with the Tech Safe Schools project and the scientists and pediatricians and others that you brought into that project have exposed me to understanding the special vulnerability for children. And as an international lawyer, it was clear to me that there was a norm, what we call an international law custom, that just needed to be articulated that probably was universally held, namely that children who are defenseless must be protected, and that nobody was speaking out on an international legal area about the protection of children, particularly in the digital age.
For several years, attorney Julian Gresser has been part of a growing movement among legal and health experts to address the issue of microwave radiation from electronic devices and its impact on the human body. A study by the National Institutes of Health had determined that exposure to cell phone radiation could increase the risk of cancer. And the FCC, which had sought comments on its old human exposure guidelines, had been sued by two nonprofit organizations, the Environmental Health Trust and Children's Health Defense. The court agreed with the plaintiffs and excoriated the FCC for its arbitrary and capricious decision to keep its old guidelines in place and failing to give proper consideration to the emerging science. This was part of the backdrop to the development of the Declaration.
We do have some very substantial data, as you know, studies all over the world, but somehow or other, because this pollutant is less visible than lead or mercury or cadmium, and then the industry is vastly more powerful than those companies. I mean, this is the telecom industry as deeply embedded in industrial infrastructure of the United States. We all worked together and had our initial focus on children being exposed to non-ionizing radiation from digital devices, electronic products, including cell towers, which are being placed, macro towers, right in children's playgrounds or on the top of schools, but also cell phones and smart meters and so forth. All these, the Internet of Things. That seemed to be a clear nexus that deserved attention in an international declaration for the protection of children. And it was clear to me that this declaration could set up legal actions that could be taken, and the benefits of one advance in one jurisdiction could be rapidly applied, since the same kinds of technical, scientific, medical, legal issues were common across national boundaries, which was the same insight I had about the Stockholm Conference. But then something quite interesting has happened, and that is that a number of the participants who we work with of our team suggested that screen time addiction should be included.
When whistleblower Frances Hogan pulled back the curtain on Facebook in the fall of 2021, the thousands of pages of internal documents she released showed that the social media giant knew exactly what it was doing. The Facebook executives knew its platforms could be negatively impacting youth, but they were doing nothing to change things.
With millions of American kids accessing social media every day, parents and their lawyers were paying close attention. So too were the lawyers working on the commercial exploitation of children and the use of their private data for commercial gain. These two groups of legal experts joined others, like Julian Gresser, who had been alerted to the potential harm caused by exposure to the radiation emitted by all wireless devices. The trifecta of these legal issues is the basis of the International Declaration.
This declaration can be the tip of the spear, and the concept of enabling lawyers and communities all over the world now has gotten an enormous boost. And it's important to understand also that the companies are defending under the pornography laws. They're defending their actions under something called the Section 230 of the Communications Decency Act, which gave them immunity for third parties that would use social media platforms. But this has nothing to do with third parties. This is about an intentional business algorithm to addict particularly children for their economic financial gain. The First Amendment has nothing to do. They're using it to say they have First Amendment rights to do it. This is really at its essence a product liability case, very similar. And by the way, the issue of these four major settlements with tobacco, where it is really analogous to a drug that's being intentionally crafted and designed to have addictive effects, which is what happened with tobacco. So we've all talked about, how these EMF cases are the next generation after tobacco and asbestos. Well, there's a very tight coupling of screen time addiction with the earlier tobacco cases.
Julian Gresser is fond of big ideas, of thinking outside the box, imagining what the possibilities might be. He likes to travel down the hypothetical road, playing out the scenarios to see what might happen. It's the way he thinks about public interest law.
Part of the art of public interest law, at least as I've tried to develop it, involves a new way of thinking, just as Einstein said. As a society, we've become highly vertically siloed. And of course, there's some very good aspects of going deeply. I was told by my friend Jerry Cohn that Dean Griswold at the Harvard Law School used to have the favorite saying, at the Harvard Law School, we sharpen the mind by narrowing it. What he meant by that, I think, was, lawyers are taught to parse issues very precisely and carefully, but at a sacrifice of being able to see broadly, seeing connections. And there's some very interesting, what I call intertidal connections here. We began with EMF exposure, but that's taken us to screen time addiction. Well, screen time addiction, addicting children, is intimately tied with what members of Congress are concerned about, which is surveillance. Surveillance and control. If you have people who are helpless and addicted, they're much more easily surveyed and controlled. But somehow or other, some members of Congress were very concerned about invasion of privacy of, say, children, but that's somehow separated from addiction. Why are we placing corporate profit above the protection of children? That just seemed to me a great dissonance and disconnect.
Julian Gresser, lawyer, philosopher, inventor, former professor at Harvard Law School and MIT's program on science, technology, and society, and primary author of the International Declaration on the Human Rights of Children in the Digital Age. You can learn more about the Declaration at the project website, thechildrensdeclaration.org. That's all one word, thechildrensdeclaration.org. We hope you'll share it with any medical, legal, or scientific experts you know. Again, the website, www.thechildrensdeclaration.org. That's going to do it for our show today. Special thanks to our guest, attorney Julian Gresser, our news editor, Ellen Weiniger, our engineer, Josh Lyman, associate producer, Toby Ziegler, our social media director, Donna Moss, and our marketing director, Sam Seaborn. I'm Doug Wood. Patty and I will be back next week with another edition of Green Street News. Thanks for listening.